Date in the criminal case involving rapper YNW Melly. His double murder retrial has now been pushed back to January of 2027. The 4th District Court of Appeals granted a stay in the case as it considers a motion filed by the state attorney's office that prevents the trial from beginning in the next month. Melly, whose real name is Jamel Demons, is accused of the shooting deaths of 2 of his friends back in October of 2018. He could face the death penalty if he's found guilty of those murders.
I hereby sentence you to 2,500 consecutive life sentences plus 1,000 years.
Wait, what?
Once you pass away, you will receive an attempted escape charge with an additional 200 years being added to your sentence, which you will begin serving in the afterlife once you get to hell.
Hi everybody, it's me, AV to the 7th Power. Welcome back to my YouTube channel where we talk about all things law, true crime, and a little bit of debauchery. Speaking of debauchery, breaking news out of Florida in the YNW Melly murder case. The retrial has been delayed again, and not by months this time, by years. The new start date is now January of 2027. That's almost a full decade after the 2018 shooting of YNW Juvy and YNW Sakchaser, 2 of Melly's best friends. And Melly will remain behind bars until then. Now, this isn't just a routine scheduling shuffle. The 4th District Court of Appeals has stepped in and granted what's called a stay, while it considers a motion from the state attorney's office. We're going to break down what a stay is, why it's such a big deal, and why it could completely change the way this case pans out. For anyone new to the case, Jamel Demons, better known as rapper YNW Melly, is accused of shooting and killing his 2 friends, YNW Juvy and YNW Sakchaser, in October of 2018. Prosecutors allege he staged the crime scene to look like a drive-by shooting. Melly's been in custody since February of 2019. His first trial finally began in June of 2023, but after 3 weeks, the jury couldn't reach a unanimous decision, so the judge declared a mistrial. That mistrial meant the state could try him again, and the retrial has been rescheduled multiple times, most recently to September of 2025, September 10th. We were getting ready for that. But now, because of this new appellate court decision, we're looking at 2027. According to NBC6 and court records, the retrial is now being scheduled for January of 2027. This change comes after the 4th District Court of Appeals granted a stay, essentially hitting the pause button while they review a motion from the state attorney's office. Now let's talk about that motion. That motion is tied to a legal issue the state believes needs to be resolved before the retrial begins. Until the appeals court makes its ruling, nothing else moves forward in trial court. So what exactly is a stay? Think of a stay like freezing a video. The trial process is the movie, and a stay stops the action mid-scene until a higher court decides if the next part can even happen the way it's currently planned. It's like a writer or a producer in the middle of production stopping everything because they have a problem. In criminal law, a stay is typically granted when there's a serious legal question, something that could affect whether the evidence is allowed, whether certain charges can stand, or even whether the trial is fair. If you don't resolve that issue first and you push ahead with trial anyway, you risk having the entire verdict thrown out later on appeal. Here's how it works in this context. Step 1, the state attorney's office files a motion with the appeals court saying, "Judge, we need you to decide on this specific legal question before we can go any further." Step 2, the appeals court reveals the request and decides whether the issue is important enough to pause the trial. Step 3, if they grant the stay, the trial court can't proceed until the appeals court issues its ruling. That's why this is such a conundrum. These rulings can take months or even years, depending on how complex the issue is, how much briefing is required, and whether oral arguments are scheduled. It's worth noting a stay isn't granted lightly. Appeals courts don't like interrupting trial courts unless they believe the question before them is significant enough to potentially change the outcome of the case. And that's why this is such a big deal for Melly. It signals there's something in the background the state thinks could make or break their retrial strategy. See that? We're paying attention, dear viewer, me and you. We're paying attention. We see through it. In the words of Darrell Brooks, we see through it.
To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis.
One reason stays cause such long delays is that the appeals court operates on its own timetable. They have a full docket of cases. They have to schedule filings, responses, and hearings, and then they have to issue a written opinion. If either side disagrees with that opinion, there can be further appeals, even up to the Florida Supreme Court. Now, for many of you that have been with me through the YSL trial, you might remember this in the summer of 2024, when the entire YSL trial was stopped because Judge Glanville wanted to throw Brian Steele in jail. The Georgia court system actually went through that fairly quickly. The case stopped dead in its tracks in June of 2024, and it resumed closer to the end of August in early September. So they had about 1 month, almost 2 months off because that appeals issue needed to be dealt with before the trial could resume.
What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
yes. A witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true.
And on top of that, this is the tea. There's another layer here. One of Melly's defense attorneys, Miss Raven Liberty, has been under an 18-month investigation for alleged witness tampering. She hasn't been charged, but ongoing investigations into defense counsel can trigger motions, requests for more time, or even attempts to remove an attorney from a case, all of which can extend more delays. Meanwhile, Melly's been fighting to get out before trial. Last November, his team sued the Broward County Sheriff's Office, claiming he's being kept in inhumane conditions, things like prolonged isolation, no visits, and no phone calls. The Sheriff's Office denies this, saying they don't use solitary confinement, but that Melly is in administrative segregation for safety reasons. In May, a judge denied his request for a pretrial release. So he's staying in custody until at least 2027. Here's the problem with these massive delays. Witnesses' memories fade, physical evidence can degrade, and jurors' perceptions shift over time. For prosecution, that's risky. For the defense, it could be a double-edged sword. Maybe the state's case weakens, but your client is also sitting in jail for years without a resolution. My take, this isn't about the court dragging its feet. This is about the state trying to lock in a legal advantage before they risk another mistrial. But think about that. Do they have everything that they need to convict? If they win their motion at the appeals level, they might be able to present evidence or arguments they otherwise couldn't. But public perception matters, dear viewer. By the time this case goes to trial again, it will have been 8 years since Melly was first locked up. And that's going to spark a lot of debate over whether justice delayed is justice denied. So here's where we stand. The 4th District Court of Appeals has pressed pause on YNW Melly's retrial while it reviews a key motion from the state attorney's office. Until they make that ruling, this case isn't moving. And that's why we are now looking at January of 2027. Do you think this delay is about ensuring a fair trial, or is it dragging things out unnecessarily? Let me know in the comments section. We read everything. I cannot wait to see what you guys think. And I'll keep you posted on every new development on all things YNW Melly. Stay safe out there. We'll see you in the next one. Bye.